Hello, my name is Matt Jackson. I'm one of the barristers at Albion Chambers. This video is a recording of a web seminar that we put together on the 14th of April this year for a number of our solicitors. We have edited a couple of technical hitches out. Otherwise, this is the same information which was given on the day itself.
As the topics we're covering are developing hour by hour, minute by minute, what I can say is that these talks were up to date as of 12 noon today. If anything's changed since then, it's not incorporated into our talks. But all the latest guidance from the Chancellor, from Her Majesty's Revenue and Customs, or the Department for Business, Energy and Industrial Strategy, they've all been distilled into these talks as of 12 noon today. Just a further point about source material. The team has been scouring all the government websites, BEIS, Her Majesty's Revenue and Customs, official Twitter accounts, the Chancellor's briefings. We've seen email correspondence between MPs. We've been asking directly questions of Her Majesty's Revenue and Customs. There's even been a High Court case that came out only yesterday that touches on the furlough scheme. And we're amalgamating all of these sources together in order to deliver these topics to you. But this is the first time in my career that I've ever been advising clients based upon a tweet. It is unexpected, to say the least. Remember, this furlough scheme probably won't be underpinned by legislation. So if we rely on these tweets, on these emails of reassurance, and then the government changes its mind, or Her Majesty's Revenue and Customs decides to go a different way, our recourse is likely to be based upon judicial review, based on our clients or us acting based upon the legitimate expectation of what is set out in those official communications. So based upon the tweets, the emails, the guidance. But there's no doubt we're in the wild west of the employment law right now, and you've got to keep your wits about you. Finally, in terms of the way this is going to be structured today, at the start of each speaker's segment, there will be a short slide which will set out the subheadings of their talk. You may want to scribble down these subheadings as a framework for when you're listening. You'll see from those subtitles that we go a little wider than just furloughing in order to put matters in their proper context and give you an overall flavour of the COVID-19 position. So let's make a start. May I introduce the first speaker, Matt Jackson. Matt is a very recent recruit to Albion Chambers, but has been a friend to Chambers for some time. You may recognise him from two places. First, his Supreme Court victory in Djibouti against Royal Mail, and secondly, his magnificent appearance on Mastermind. Do look on YouTube for it. Finally, if you go and watch county cricket at all, you may recognise him as the only other spectator in the stand. So on that basis, I'm going to hand over to Matt, who's dealing with a furlough scheme.
Good afternoon, everyone. Hopefully you can hear well, and I hope everyone's keeping safe. As Richard said, what I'll be talking to you about is going to be the furlough scheme. That will be based on the situation as it stands, as you've heard from around 3 or 4 hours ago. I'm looking at 4 topics. They are: what is the scheme? Who is it for? What is no work? And in that context, you'll note in due course that people are being required to be put off from work entirely for a period of around 3 weeks. And finally, how does that scheme operate in practice? So first of those, what is the scheme? It is a non-statutory scheme. There is some provision in the Coronavirus Act 2020, section 67, for those of you who want to have a look, but you won't see a great deal there, if for no other reason than simply it says that the Treasury can direct there to be schemes in place. It is important to bear in mind that there's unlikely to be any form of legislation in this area, as the wide power in the Act allows the Treasury to do effectively what it wants without needing secondary legislation. Most employers will have to rely on what the government has said so far, and if necessary, deal with judicial review later. It is important to remember that the scheme is based on grants to employers and is not based on separate statutory rights created for employees. It does not change statutory or contractual rights. The scheme, in short, provides for around 80% of pay, sorry, that's up to 80% of pay as a grant to employers. That includes the statutory minimum pension and the employer's national insurance contributions. Both of those, however, are based on the 80% rate of pay, not on the normal rate of pay. For any employee, they have to be put off for work, as I've said, for at least 3 consecutive weeks. For those people who are involved in the furlough scheme, they must have employees who were on the PAYE system on or before the 28th of February this year. There are some exceptions to that, which we'll come to in due course, but in essence, there must have been a PAYE record and real-time information for an employee prior to the 28th of February 2020. An employer must also be enrolled for PAYE online, and they must have a UK bank account. And what has been made clearer in recent days is that those employees who are covered are any normal full-time employees, part-time employees, atypical workers, 0 hours contract workers, agency workers, apprentices, directors who are remunerated through PAYE, and any other Lim B worker. So that is someone who has to provide services personally, but not those who are entirely self-employed. In essence, what the Treasury have been doing and what HMRC will be looking for are those who are paid through the PAYE system and who have a record via HMRC for those people. One of the issues that's also been controversial until recently is what the situation is as regards those employees who have been dismissed or who employers were planning to dismiss. What is clear is that there is no requirement under the scheme that an employer was proposing to or even thinking about dismissing a particular employee. Equally, anyone who has been dismissed can be re-engaged, including people who are fixed-term workers whose contract has expired. And once those people have been re-engaged, they are then permitted to be furloughed and the grant can be claimed under the HMRC scheme. There has as well until recently been a situation where it's not been clear whether people who are off sick are covered by the scheme, and if so, to what extent. The current position seems to be this: anyone who is in receipt of statutory sick pay cannot be furloughed whilst they are receiving statutory sick pay. However, an employer is entitled to and doesn't have to have a reason for taking them off statutory sick pay and immediately placing them on furlough. There are situations where one may have to consider costs. Of course, you can recover at the moment both statutory sick pay and furlough pay via HMRC and reclaims. But it's also worth bearing in mind you can't claim for both statutory sick pay and furlough pay for the same period of time. People who are shielding or who have been advised to remain inside, or are otherwise on long-term sick can be placed on a furlough, and there has been no restriction placed on that by HMRC. What they have said is it's not intended to cover people who would otherwise be on short-term sickness. There hasn't, however, been any indication of how that would be enforced. It simply seems to be the case, if you take the view that you don't need an employee at work and you are able to agree within the position, which I'll come back to in a moment, that you can furlough them and take advantage of that scheme. Further questions are also arisen in terms of people who are employed on particular visas, whether that be a tier 2 visa will be the main visa in for most people, or another one. A lot of those visas have a stamp saying no recourse to public funds. HMRC has now clarified, however, that that is not a restriction on a furlough scheme payment being made. It is not a public fund for these purposes if someone is working on a visa. So that is a brief rundown of what the scheme is and who qualifies for it. What does it mean, though, in terms of what is being away from work and what does no work mean? Well, there hasn't been any explicit guidance given on this particular issue. Some of it seems to be clearer than others. So, for example, training is not included in work. You can still send employees to be trained, and that particularly includes apprentices. They can still go to their training, whether it be in a college or other forms of training. It does seem to include anything that develops economic or other activity for an employer. But beyond that, it seems to be unclear exactly what no work means. The safest possible option to avoid any issues coming up is simply to say, go home, turn off your email, don't log into the system. If you do log into the system, we'll kick you out or find some other way. But what is the safest practice is to make sure that an employee has no contact with work other than the usual contact you might have outside of a work setting. That, however, shouldn't be used as an excuse to try and get them to do work whilst they're at home. Because if at any point during a 3-week furlough, an employee starts doing work, that interrupts the whole process, and the claim for any period is then entirely invalid. On this particular point, the government has been less clear, so it's probably safer to adopt the safest possible practice for this purpose rather than simply chancing your arm at the seams of things. The question then arises, and this is again somewhat more complicated, how the furlough scheme is going to operate in practice. As I said at the start, the job retention scheme, as it's officially called, does not alter contractual relationships. There are no statutory rights created, and there are no other alterations to existing contractual rights. For that reason, employers will not generally have a right to insist upon an employee being placed on furlough. The only likely exception to that is if a contract has an express variation clause in it, which permits the terms of pay, and form of work to be altered. But except in that scenario, the position will have to be done by agreement. If there is an existing union who is recognised in the workplace, the safest option is likely to be to consult with them in the first instance. The situation other than that, once one has moved beyond, simply consulting with unions, if there is one, the situation will have to be one considers consulting directly with employees. That will, of course, be different depending on the size of the workplace. There is no formal need to consult with electing representatives or doing anything of that nature. What is important, however, is that what is done is by agreement. It is probably best to consult either with your union or your employees over the course of a few days, if that hasn't already happened, and to do individual agreements or collective agreements, if they exist, to vary the terms of employment for the period of a furlough and for the period in which the furlough scheme is in place. It does not seem at this stage placing people on furlough would engage the collective consultation requirements that are found in the Trade Union and Labour Relation Consolidation Act. However, if a furlough is being considered alongside the possibility of dismissals and that the numbers are engaged as you would expect, that's more than 45 in 90 days, then you will have to consider whether or not you need to consult as well. Because if there is a proposal to dismiss, that is an expectation that that number will be engaged, collective consultation will be engaged. If, however, you're simply talking about furloughing, it seems that the collective consultation doesn't arise, and all you will need to do is consult individually or with unions, as the case may be. The question you then go to is, well, how do I get hold of the money? So once you've furloughed someone and you've placed them on furlough, or indeed if you already have, it seems to be the case that we'll be looking at a system going live sometime around the 20th of April. That's subject to change. We're aware that HMRC is currently beta testing the online portal where these claims can be made with a select number of employers in different parts of the country. What you will in due course need to put in that claim, however, are national insurance numbers for the employees who are off, the names of the employees who have been placed off, the payroll or works number if one exists, Where someone is being paid via PAYE but is otherwise self-assessment, their unique taxpayer reference, or of course the corporation tax unique taxpayer reference, or a company registration number where you're looking at a personal service company. And the same will be the case for the employer. You will also need the PAYE reference number, the period for which the claim is being made, and HMRC has said you can make ongoing claims, you don't simply have to wait till the end, as well as a UK-based bank account and contact details. I said at the start that the amount that you can put into that claim is 80% of normal pay. That is, if for a salaried employee, the salary as of the 28th of February this year, or if they have been employed for less than a year, a prorated amount equivalent to an annual salary. For people whose pay varies, it's the higher of the same month in the previous year, so February for 2019 versus February for 2020, or their average earnings for the tax year, April 2019 to end of March, beginning of April 2020. If they have only started in February and they're on a variable pay, you prorate their earnings so far during the course of their employment. Normal pay is calculated, so this isn't a week's pay under the Employment Rights Act. There's no special calculation, but you must include all wages, past overtime, any fees or compulsory commission. There's suggestion there that there is discretionary commission. It's not something I'm particularly familiar with, but it's only compulsory commission which is included, but it does not include tips, discretionary commission, as I say, any payments in kind, even if those payments in kind are taxable and you need to submit a P11D for them. And what you have to pay to the employer has to be everything you receive. The rules of the scheme do not permit you to deduct an amount for administration costs or anything of that nature. You can have an agent submit the accounts for you, only if they are not just a file-only agent. If they're just a file-only agent, you can't use them. But otherwise you can use your accountant in the usual way. There are some special rules on people returning from maternity, paternity or adoption, etc. leave, but they are quite complex and you may need to seek specialist advice for those areas. Individuals who have employees such as nannies, home staff, au pairs, etc. aren't taxable. Everything else is where there's economic activity involved. So hopefully in a relatively short period of time, that's a whistle-stop tour of the scheme. There's quite a lot of detail which is going to come in due course, but hopefully for the moment that gives you the start of it. And I'll hand over now to Phil Smith, who's going to talk to you a bit more about pregnancy and furloughing.
Good afternoon, everyone. My name is Philip Smith, and I'll be talking to you briefly about some of the relevant issues concerning pregnant employees during the COVID-19 outbreak. Within that topic, I will be focusing on the statutory duties of risk assessment and the additional steps employers are required to take where they have received notification from the employee that they are pregnant, have recently given birth, or are breastfeeding. And I'll also touch on a few points in respect to the government's furlough scheme. Now, starting with the ordinary duty of risk assessment, the employment lawyers among us will be aware that every employer is under a duty under Regulation 3 of the Management of Health and Safety at Work Regulations 1999, which I'll refer to as the MHSW regs, to make a suitable and sufficient assessment of the risks to the health and safety of its employees to which they are exposed whilst at work. Now, such assessments obviously serve to identify the measures the employer needs to take to comply with the relevant statutory requirements and prohibitions to which they are subject. Employers are required to review their risk assessments where there has been a significant change in the matters to which they relate. And so all employers should have done that in the light of the COVID-19 outbreak. Now, where new or expectant mothers are concerned, the duty imposed under Regulation 3 is supplemented by Regulation 16 of the same regulations, which sets out the additional duty on employers to conduct risk assessments. This relates specifically to the potential risks to the health and safety of new or expectant mothers or their babies. The duty imposed by Regulation 16 is broken down into two separate obligations, a general duty and a specific duty owed to individual employees. Now, the general duty on an employer under Regulation 16 arises where its employees include women of childbearing age and their work is of a kind which could involve a risk by reason of their condition to the health and safety of a new or expectant mother or to that of her baby from any processes or working conditions or physical, biological or chemical agents. Now, biological agents in this context will obviously include the COVID-19 virus. And it's also worth noting at this point that the government and NHS guidance places pregnant women in the category of people who are at increased risk of severe illness due to the virus. In most cases, it's likely that much of the risk posed by COVID-19 to a new or expectant mother, or indeed to her baby, identified under such general risk assessments will be eliminated, or where that's not possible, reduced by strict adherence to the government guidance. For example, we are all aware that everyone is required to work from home at the moment unless that's not otherwise possible. However, there will clearly be situations where a proper risk assessment, particularly in respect of employees still physically present at workplaces, will identify further measures which can and indeed should be taken. For example, it may be that employees cannot maintain social distancing from others in the workplace or while otherwise at work. Some of you may have read reports in the news in the last week or so from Royal Mail employees disclosing that social distancing was almost impossible in busy sorting offices. In such a case, employers may, for example, wish to consider provision of personal protective equipment to manage that risk. Now, the general duty to undertake a risk assessment is just that, it's general. It seeks to analyse the risks that might affect any new or expectant mothers or their babies, but it doesn't require individual consultation or consideration of individual workers. There is no requirement under the general duty that an employee has actually notified her employer that they are pregnant, have recently given birth or are breastfeeding. But that does take us on to the specific duty under Regulation 16, which is triggered by notification. So where an employer receives written notification from an employee that she is pregnant, has given birth within the previous 6 months, or is breastfeeding, a further duty arises to carry out an individual risk assessment of that particular employee's situation. Now, there is a multitude of things that such an assessment could take into account. But for example, how does that employee travel to work? If public transport is the method of travel and that's all that's available, that's likely to carry a higher risk of infection than if she were to travel alone in her own car. Now, if following notification by the employee and completion of an individual risk assessment, the employer comes to the conclusion that, firstly, the notifying employee continues to be subject to a risk by reason of her condition to her health and safety or to that of her baby, and it's not possible for the employer to take action to avoid that risk, the employer must take one of the steps set out at sub-regulation 16.2 and 16.3 of the MHSW regs. These are as follows. Firstly, the employer must make reasonable alterations to the working conditions or hours of the employee if that alteration would have the effect of removing the risk. If that were not possible, however, or if the risk were not removed by such alterations, the employer must instead offer suitable alternative work to the employee if it is available. And if all else fails, the employer must suspend the employee on full pay for so long as it is necessary to avoid the risk. Just on the alternative work point, it should be noted that while an employer's failure to offer alternative work, if it is available, may give rise to an employment tribunal claim under section 70, subsection 4 of the Employment Rights Act 96, an employee is actually under no obligation to accept alternative work offered to her, even if it is suitable. However, if the employee is suspended because her job is potentially dangerous and she's unreasonably refused suitable alternative work, then she will not ordinarily be entitled to pay during the period of her suspension. If that situation were to arise in the current circumstances, or was likely to, the employer and employee may simply prefer to agree to her being furloughed to take advantage of the government furlough scheme. One other point in terms of the lack of availability of alternative work is that that may itself raise the spectre of redundancy if the employee's actual role appeared to no longer be viable, notwithstanding the fact that she was pregnant. In such circumstances, using the furlough scheme to preserve the job in the interim, that being the purpose of the government scheme after all, is likely to be preferable as a holding position, so that any decision about redundancy, if that is something that may need to be moved on to, can be made when we return to more normal circumstances. That takes me on to the final area really of my talk. Matt's already spoken about the furlough scheme in some detail, and I don't wish to cover areas again, but I did want to just cover two additional points. The first is the interaction between the furlough scheme and maternity leave. It's important to say that the scheme does not override the normal rules for maternity and other forms of statutory leave, and they continue to apply. The scheme doesn't create new rights, and it equally doesn't extinguish those already in existence. And under the Maternity and Parental Leave, etc. regulations 1999, many of you will be aware that an employee's ordinary maternity leave commences with the earlier of 3 specific dates. Those are the date on which she notifies her employer as being the date that she intends to start her maternity leave. The second date is the first date after the beginning of the 6th week before the expected week of childbirth, on which she is absent from work wholly or partly because of her pregnancy, or finally, the day on which childbirth actually occurs. So whichever is the earliest of those dates is the date of her ordinary maternity leave starts. Now, where an employee is suspended from work pursuant to Regulation 16.3 of the MHSW regs, this will almost certainly constitute her being absent from work wholly or partly because of her pregnancy. If such a suspension starts on or continues after the first day after the beginning of the 6th week before the expected week of childbirth, then that suspension will likely trigger the start of the employee's maternity leave. Therefore, where an employer has suspended an employee in accordance with Regulation 16.3 and this triggers her maternity leave, the employer will be liable to pay usual maternity pay due without any government assistance, at least under the furlough scheme. And the final point, Matt mentioned in his talk the change to the guidance recently, which now allows employees who are currently on statutory sick pay to be taken off and then furloughed. This would obviously include pregnant women who are off sick, but it should be said, if their absence from work is wholly or partly due to their pregnancy, that may trigger their maternity leave period as well. That concludes my topic, ladies and gentlemen. So if I may now hand you over to Alec, who will be addressing you on furloughing and 2P.
Hello, and welcome to my dining room, where this is taking place today. I'm covering the topic of a question which was a very big question just 4 days ago, but thankfully isn't a big question anymore because it has in fact been answered. And that question was, if you transfer employees under 2P while this is all going on, can you claim under the furlough retention scheme for their pay? And this was originally a problem. The good news is not a problem anymore. But let's look at the long answer, which I put on the slide, because what this area of the guidance and how it's changed as the week has gone on is demonstrate the approach that the government is taking, and also, as we saw yesterday, if you haven't heard about it, but I'll discuss that in a minute, how the courts are looking at it, because we've just had our first judicial decision underneath the guidance. So 2P. Now, I know everyone here isn't necessarily an employment lawyer, so they may not know what 2P is. For those of you who are employment lawyers, you'll know that 2P can be quite a scary word, but I'll do it as quickly as possible. So 2P is the Transfer of Undertakings Protection of Employment Regulations. And that exists to ensure that when an undertaking or a business is being transferred from one owner to another owner, so a really common example is where a local authority decides that it's going to outsource some of its work. At the end of the day, the same people will be doing that work. They'll be the actual people on the ground, and they won't change from one day to the next. But the company who is in charge of them could change. So what 2P does is it ensures that those employees aren't made redundant because of the transfer, and that they retain all of the rights that they've managed to gain during their employment. So they are transferred with all of their years of service already in place, and it creates a legal fiction. We all love those, of course. And the legal fiction is essentially that after the transfer, the law treats the employee as if they had always worked for the new company, which is really useful in circumstances where that's necessary. The problem is this, or was this, under this furlough scheme, as Matt was discussing earlier, you have to be on the current employer's PAYE roll on the 28th of February. Now, obviously, if you were transferred under 2P on the 1st of March, you weren't on your current employer's PAYE roll on the 28th of February. Because although the legal fiction protects your rights between you and the employer, that doesn't change the reality, which is that you just weren't on that PAYE roll. So immediately, people looking at the guidance as it stood even 7 days ago and saying, well, hold on a minute, this is really bad because we've got a scheme under 2P, which is designed to protect employees, and we've got this brand new scheme under the CJRS, which is designed to protect employees. And the way they work together means that we won't be protecting these employees. So that was the big problem. And then in a really good example of how fast this is moving, last week, David Johnston, MP, he had emailed the Treasury, because when you're an MP, you can do such things quite happily. And he said, look, I've got these constituents who are worried about 2P transfers. Are they covered? And an email came back from the Treasury on the 6th of April that said, well, yeah, they're covered, they'll be fine. And then that email went round the Twitter sphere and all sorts of places. I got a text message from Shep a couple of days later, and that directly contradicts their own guidance. So then we had this lovely position where the Treasury was saying, yes, they're fine, but their own guidance was saying, no, they weren't. And then you had other people talking, as Richard did earlier, about the possibility of a judicial review if the Treasury changed their mind. Fortunately, they updated the guidance on the 9th of April, so just last week, and they have now made it explicitly clear that yes, people who are transferred under 2P will be covered by the CJRS, so they can be put on furlough, which is exceedingly good news for everyone involved. So if your employee, or you know of an employee who was transferred after the 28th of February, they are still covered by furlough. Now, we already had a question on this topic from Chris Aldridge from BPE, and he asked, well, how does this work practically? If we had an employee who was already furloughed with their previous employer who is now transferred, do they continue the furlough, or do we have to start a new furlough? And at the moment, there is no clear answer to that question. And even between the five of us discussing it before we started today, we had different opinions. But my hope is, I'm pretty confident in this hope, that the way that we're seeing how this guidance is working in its best way to protect employment is that the reality on the ground for the employee won't change. They won't have to stop being furloughed just because they've been transferred and wait. So even if the new employer has to start a new furlough claim, or if it just continues as if it was the same furlough throughout, the practical difference to the employee on the ground, in my view, is going to be minimal. They're not going to notice a difference because whatever the answer is, I cannot see it creating a gap from a 2P employee to fall into. So there's Then a couple of side points on this, which have also come up. As the guidance was updated for 2P, it was also updated on the same day to cover the topic of payroll consideration. Or consolidation, sorry, it's payroll consolidation. So what that means is if you have a group of companies who are all in one corporate group, all owned by one big company, and a decision is taken to transfer all of the employees from different companies onto one PAYE role, they can still be furloughed as well, just because they weren't on the company's PAYE role before they were consolidated, they're still protected by 2P. And then the last point I want to talk about is what happened yesterday and over last week. So as you may have heard, Carluccio's, which is an Italian restaurant chain, has gone into administration as a result of the COVID-19 crisis. And their administrators were then suddenly quite concerned about how the furlough scheme will apply to them. And this wasn't a question of whether it will apply, because the guidance has been relatively clear throughout that it will apply to companies and employees who are under administration. But the administrators were concerned because the way that the scheme works is it's not a claim by the employee, it's a claim by the employer, which means the administrators, who are now effectively the employers for the workers of Carluccio's, will be receiving money from the government ostensibly to pay the employees. The problem was that's money coming into a company under administration, and under the insolvency laws, money that comes into a company under administration has to be divvied out in order of priority, which means that this money could come in to protect the employees, but could actually then have to be divvied out to other creditors of Carluccio's, which is a less than ideal situation. So it went in front of the High Court last week. They had remote hearings, and they had to get the judgment out by yesterday because of a 14-day time limit, which applies when administrators take over companies and start looking at them. And it's a really interesting example of how the courts are going to treat this guidance. It's also an interesting illustration of how unclear things are even to the judiciary, because the first thing that Mr. Justice Snowden commented on was he's working off the guidance himself and is quite keen to see the legislation that will underpin it, not quite realising that that isn't actually the plan at the moment to make any legislation. So he obviously didn't read as far into the explanatory notes as other people have. But his approach was very much a practical approach to achieve the right result. And I won't bore you with the ins and outs of the insolvency situation, but what he has decided is that the way that this scheme works and the way that it can be adopted by administrators ensures that the employees of Carluccio's will have what they call super priority in the hierarchy of creditors. So this money will come into the administrators from the government of Carluccio's, and then they can put it to one side and pass it on to the employees. It's well worth a read if you are into this particular topic. It could be a bit of a growth area because, of course, Debenhams has announced administration, and I'm pretty sure there are some other companies who've recently announced that they've gone or going into administration over the last week. So it's quite an involved decision for insolvency law, but it's not actually that difficult to understand. But it's a really good example of the approach that the court is taking, which was, okay, this has to bring me to the end of my topic. So in short, if an employee is transferred under 2P, they will be protected by the furlough scheme. At which point I'm going to hand over to Lucy Taylor.
Okay, so the first point I'm going to deal with is constructive dismissal and Section 44 of the Employment Rights Act. So what Section 44 protects is it protects employees from being subjected to a detriment as a result of them either refusing to go to the workplace, going home from the workplace and refusing to go back, or refusing to attend a dangerous part of the workplace. So that's one way that they would be protected. it also only kicks in if the employee perceives that there's an imminent and serious danger in the workplace. So that's the context in which they could say, look, I'm not coming in. And obviously we're coming at this from the coronavirus angle of things. The other situation that Section 44 would cover is if an employee takes appropriate steps to protect themselves or other employees from that serious and imminent danger that they reasonably believe to exist in the workplace. Now, in relation to that particular aspect of things, the taking action aspect of things, what the courts will consider is all the circumstances that existed, in particular the knowledge that the employee has, any guidance, any advice that's been given. So what we would be looking at is gov.uk website, nhs.uk websites, any daily government briefings, that kind of thing, because that would be what's informing all the circumstances and an employee's reasonable knowledge in the current climate. If it was a coronavirus type case and employees are taking this type of action of refusing to go into the workplace or taking what they deem to be appropriate steps. And if an employee is subjected to a detriment and as a result they say, look, I'm not working here anymore, I don't like what's happened, I don't like how you've treated me as a result of me trying to keep myself safe, for example, they may well be able to bring a claim for constructive unfair dismissal if that's what we call the straw that broke the camel's back and caused them to subsequently leave their employment. Now, an employer may have a defence to such a claim if they can show that the action, so we're just looking at the limb where an employee takes action to protect themselves or protect others in the workplace, if an employer can show that that action was so negligent that a reasonable employer might have treated that employee in the same way, they may well have a defence to any claim for constructive unfair dismissal. Now, what type of situations would we be looking at in terms of potential dangers in the workplace? Well, we all know that we need to maintain social distancing and stay 2 meters apart. So that's one. For example, if people worked in a shop and they kept coming into contact with members of the public when that could be avoided, that would be another scenario. We've all heard about the issues with PPE and whether sufficient PPE has been provided. That's another consideration. And also, we should be looking at if it's possible for people to work from home and an employer isn't permitting that to happen. If an employee says, well, I'm not coming into work because I don't have to, I can work from home easily enough and there's a serious and imminent danger that I may get coronavirus in the workplace, then, and they're subjected to a detriment, they may well have a claim for constructive unfair dismissal if they leave their employment. Some practical examples: the Passport Office has been in the news recently, where the Passport Office is trying to make employees go back into the workplace because what they're suggesting is employees need to help get rid of the backlog of applications because otherwise it will be unmanageable when the lockdown is lifted. And employees are quite concerned about that and suggesting that it's completely contrary to the government guidance and they shouldn't have to go back into the workplace because it's not urgent work that needs to be done, particularly with the restrictions on travel. There's also Holland & Barrett, which has been in the news recently with the employees starting a petition to close Holland & Barrett stores, stating that there's inadequate hand washing facilities, there's no PPE, they're having to come into contact with members of the public and break social distancing rules, and there's inadequate hand sanitisers available for use. Holland & Barrett says that while they're an essential business, they provide supplements and health foods for people with certain medical conditions. So they are an essential business and they need to remain open. So if those employees said, I'm not coming into work as a result, or they took action to protect themselves or others, and they were subjected to a detriment and they subsequently left their employment, they may well be able to bring a claim for constructive unfair dismissal in the circumstances. This particular piece of part of the Employment Rights Act only applies to employees. It doesn't apply to workers. So you've heard Matt Jackson mention Limb B workers being protected under the furlough scheme. They wouldn't have protection under Section 44 of the Employment Rights Act if they were to bring a claim. But if they made a protected disclosure because of health and safety concerns, then they may be protected under the whistleblower provisions if they're self-employed or a worker. But I'm not going to go into that any further because most of you, particularly the employment specialists, will know that that's a whole big topic in itself. Section 100 of the Employment Rights Act, so this is the second point on the slide, health and safety reports and dismissal. It's worded the same in terms of employees not going into work or taking action if they reasonably believe that there's a serious and imminent danger. But instead of protecting employees from being subjected to a detriment, it protects them from being unfairly dismissed. So if the principal reason for dismissal is any of the circumstances that we've already discussed in terms of the various considerations. So, for example, if there's inadequate PPE and they refuse to go into work as a result and they're dismissed, they will be able to bring a claim for unfair dismissal for health and safety reasons. The same considerations apply if an employee takes appropriate steps to protect themselves or other employees. So we'd then be looking again at their knowledge and what guidance had been given, what advice had been given in all of the circumstances. And again, an employer may well have a defence to any unfair dismissal claim if they can show that the actions of the employee in seeking to protect themselves or other employees were so negligent that a reasonable employer might have dismissed them as well. And the same examples apply if you just think of what the outcome might be if the people in the passport office refused to go in, for example, and they were subsequently dismissed, then they may well have a claim for unfair dismissal under Section 100. And then likewise, if they're subjected to a detriment, as we've already discussed, they could have recourse under Section 44. The effect of an unfair dismissal under Section 100 of the Employment Rights Act is the same as any other unfair dismissal. I have mentioned how much could it cost on the slide, which was point 3. Section 120 of the Employment Rights Act provides for a minimum basic award for certain unfair dismissals. Unfortunately, the health and safety related unfair dismissal that I have mentioned just now isn't subject to that basic award. So that's the only point I wanted to make in relation to that. I've also included the Health Protection Coronavirus Restrictions Regulations 2020. I apologise, that's quite a mouthful to say and to read actually. There are different regulations for England, Scotland, Wales, Northern Ireland, and I know there are some people joining into this from Wales. I've looked at the English provisions, but they seem to mirror each other as I understand it. So what it provides for is those businesses that have to close, those businesses that are essential businesses, supermarkets and the like, and those businesses that can carry on operating if they provide consumers with the option to purchase online or by postal order. And the reason why I am mentioning these regulations is because we do need to look at an employee's belief when we're looking at Section 44 and Section 100. And if an employee works for a business that is required to shut under the regulations, then it's more likely that their belief that there's a serious and imminent danger is a reasonable one and is more likely to support what they say in relation to that, and potentially that they've been subjected to a detriment or they've been unfairly dismissed. So that's all I want to say in relation to that. The regulations are quite short and it's quite straightforward once you've taken a few minutes to get your head around it. So I'll just signpost them. And an example in relation to that particular part of my talk is Sports Direct, that you all might have heard about at the beginning of the lockdown, when Sports Direct was proposing to stay open, suggesting that sports equipment was essential and they should stay open as a result. I'm sure you've all heard about it. I won't say anything more about it than that, but it is relevant to these considerations, particularly that last part. I'd just like to apologise once more for the technical difficulties I've had. We did have a run through yesterday, so I'm sorry that wasn't it wasn't as straightforward as yesterday when I've come to do my talk today. But on that note, and with my sincere apologies, I'll conclude my topic and hand over to Richard, who hopefully his part will be as smooth as it was at the beginning.
Hello everybody, me again. Dealing with holidays, you'll see on my slide I've got 5 separate topics: holidays, the issue; holidays, the debate; a bloke called Steve, his tweets and the latest guidance; calculating holiday pay; and also why make it difficult, I ask at the end. So as we're limited for time, let's get straight to the nub of the issue. If the current social distancing and stay-at-home rules persist over an extended period, this means that many businesses and organisations will have a vastly reduced amount of work to do. Think catering and hospitality. As just one example, pubs reimagining themselves as takeaway or food delivery services. Again, the reduced workforce involved in that. Or going even further, absolutely no work whatsoever because they've had to close by rules of the state. Think gymnasiums as a good example. And in our own businesses too. Your firm may do conveyancing, which is going to face some very challenging times. Or crime, where jury trials can't happen because of social distancing. Or employment tribunals, particularly discrimination trials, where we need to have a panel of 3 together to make that decision. So the furlough scheme, as we've heard, is intended to fill the gap, to stop employees being dismissed. But because these workers are still employed, they're on the furlough lifeboat, or all of their statutory and contractual rights are similarly preserved, and that includes holiday. So every day that an employee is furloughed, they are accruing a fraction of a day's holiday. And let's say for ease of mathematics, employees get 5 weeks holiday a year, let's just say that. They're going to accrue a week's holiday every 10 weeks. Ordinarily, this isn't a problem because the workforce will take their holidays at various times of the year to suit themselves. Legally, as we know, an employer can refuse a particular date if there's good reason, but by and large, it sorts itself out. But let's focus on our situation. Nobody is taking holiday currently because they're sitting at home. So the furloughed workforce up and down the country, millions of workers, are storing up its holiday days, and they'll be used later in the year. And everybody will be taking holiday during the same half of the year, just when those businesses and organisations need to be operating at maximum capacity to mitigate the effects of the massive downturn in trade or work that we're currently dealing with. The other aspect, and it's worth noting, is that the working time regulations have been amended in response to CV19, now allowing employees to carry over 4 weeks of holiday into future years. That may also alleviate the effects of the holiday stockpiling issue, but I always think that carrying over holidays is just kicking the can down the road. Employers need to think about and try and resolve this issue sooner rather than later. So let's get involved into the debate, the next heading on my slide. So the first question is, do employees accrue holiday days whilst on furlough? The answer is an unequivocal yes. Workers do accrue holidays in just the same way. For the employment lawyers, think of it as equivalent to accruing holidays whilst on sick leave or maternity leave. Furlough periods should be treated in exactly the same way. And this is where the bloke Steve comes in. You'll remember him from my title slide. Steve is one of the operators of the Her Majesty's Revenue and Customs Twitter accounts. And he was the first person, whoever he is, to confirm that workers would still accrue holiday. I think it was Wednesday last week or thereabouts. And this is now incorporated into the general ACAS guidance and so forth. So it seems that's the direction of travel. Next, can employees choose to take holiday whilst furloughed? Let's put this into context. At the moment, due to the social distancing rules and other restrictions, we can't imagine anyone would want to take holiday. There's nowhere to go. But imagine 3 months' time, many restrictions have been lifted, that family groups are now allowed to travel to different places in the UK, but our personal trainer in the gym is still furloughed. They may want to take holiday, maybe borrow that hillside cottage of the Chief Medical Officer of Scotland, for instance, so I don't think she'll be using it anytime soon. But because furloughing requires the employee to be ready for work on pretty tight timeframes, they might want the certainty of booking out holiday in the usual way. Well, again, the answer is yes. The employee can choose to take holiday. Again, a nod to the employment lawyers, but that ECJ decision of Stringer, which says someone on long-term sick can take holiday, seems to apply equally here. Someone furloughed can take holiday. Why not? Again, Steve, our Twitter hero, confirms the same, and this is now recorded in the latest ACAS guidance. So employees can choose to take holiday in the usual way. Next, can the employer make an employee take holiday during their furlough period? Before answering this question, why would an employer want to do this? Well, it's that point I was making earlier. An employer may want to distribute holiday evenly across the year, so once the current restrictions are lifted, they're not faced with a situation where all their employees have gone to Torremolinos at the same time. But returning to the question, in just the same way as for employees, employers can make employees take holiday during the furlough period. But the usual rules apply. If you're going to make employees take holiday, you must give twice the period of notice of the period of holiday you're making them take. So if you want them to take 5 days, then you need to give them 10 days notice. Nothing has changed there. But a question that I've been asked is, wouldn't somebody taking holiday, either requested by employee or stipulated by the employer, couldn't that interrupt the minimum 3-week period for the furlough scheme? And in consequence, couldn't this jeopardise the grant the government would pay? It's certainly a real concern. It's something that I've corresponded directly with Her Majesty's Revenue and Customs about personally. That was due to a client I was advising. If you look for Steve's tweets, you may even discover my anonymous Twitter handle. But what they confirmed is that this would not jeopardise the 3-week minimum period. And this applies to bank holidays as well. So now, I'm a little surprised by that answer, but the tweet, but also the follow-up guidance is categoric about it. It's allowed. But me, being the cautious soul that I am, I say, why take the risk? If you or your client is concerned about the stockpiling of holiday, or an employee wants to take holiday, why not simply allow the minimum of 3 weeks furloughing and then allow a week to be taken as holiday thereafter? Why take the risk, especially where we're relying on tweets? You may even decide to wait until the government says restrictions are likely to be lifted on date X, and at that stage make all furloughed employees who you intend to unfurlough take as many days leave as possible at the tail end of that period. Again, subject to the twice a notice period I've just been talking about. Doesn't that solve the problem? Finally, let's talk about money. If an employee takes holiday whilst they are furloughed, the furlough grant will still be paid to the employer at the 80% £2,500 rate that we've already heard about. But the employer will have to pay the worker at their usual holiday pay rate, so their full salary rate. I'm not going to get into how to calculate that here. That's a non-furlough standalone topic on its own. And for workers with work with fluctuating hours, that method of calculation in fact changed on the 1st of April this year. But in short, if the employee is on holiday, they get paid their full rate. If they take that holiday whilst furloughed, the employer will receive the furlough grant rate. And here's a downside to the proposal I made a few minutes ago. Depending on how it's structured, of making everyone take standalone holiday at the end, if you unfurlough those employees and then make them take holiday, then there would be no furlough grant for the period of that holiday. So if my approach is adopted, or at least the style of that approach, make sure that employees remain furloughed. Make that clear in correspondence, but make it clear that they are to take holiday whilst furloughed. And that should, and I underline the word should, mean that the employer still receives the furlough grant. And this can be used to set off against the full rate being paid to the employee. And that moves me on to my final point regarding money. An employee may want to take holiday to boost their income. Let's say they are struggling, as many are. They're furloughed, so they may be receiving 80% of their salary without top-up, because this is the grant their employer is receiving. If the employee needs to receive a little extra that month to cover their increased electricity bills, for instance, then tactically, they may choose to take all of their holiday to ensure that they are getting their full salary. The employer, as always, can say yes or no to this, but the cost to the employer will only be the difference between the furlough grant, the 80% £2,500, and the employee's usual salary. So it might be something to consider. So there we have it. That's a whistle-stop tour of holidays and the furlough scheme. And that brings us to the conclusion of this seminar. No doubt you're all in muted, rapturous applause right now. Thank you for that, by the way. But may I say thank you to all of you for joining us on this sunny afternoon. May I say thank you to Nick Jeans, our clerk, who has coordinated all of this in record time. To Matt, Lucy, Alec and Phil, who have worked tirelessly over the last fortnight to stay ahead of this rapidly changing field. When I see them, when I see you, I'll buy you a nice glass of something cold. In conclusion, remember you can email your furlough queries to Nick and we'll collate and respond to them. And any feedback is much appreciated. Stay safe, everybody, and we'll see you very soon.